Welcome to the Friedmann Firm Podcast, Ohio Employment Law Guide.
Welcome back to the Friedmann Firm Podcast, Ohio Employment Law Guide with attorneys Rachel Sabo Friedmann and Peter Friedmann, co-founders of the Friedmann Firm. Rachel and Pete represent employees across Ohio in cases involving discrimination, retaliation, harassment, wage violations, and other workplace issues. They're known for straightforward, practical guidance that helps workers understand their rights. I'm Leanne Lyon, and today we are breaking down what a hostile work environment actually means under Ohio and federal law. Hello, Rachel and Pete. Rachel, when somebody feels targeted, belittled, or singled out at work, what is the first thing that they should pay attention to in deciding whether the situation may have legal significance?
So I think the first thing to understand is what the term hostile work environment actually means legally, because this is another legal term that is very misunderstood. So a hostile work environment, in order for it to be unlawful, it has to be based on a protected class. It can't just be bullying or a rude coworker or, catty coworkers gossiping about you. It has to be based on a protected class. And what I mean by that is the harassment or the comments or whatever it may be that's causing the hostile work environment has to be based on, a disability, pregnancy, age, religion, military status, something that is legally protected under the law. Another good example that causes a hostile work environment is sexual harassment. So that is something that everyone needs to understand, is that it really does need to be a protected class in order for it to be a hostile work environment legally.
People often describe a workplace as toxic or hostile, but those words mean something different in the legal world, as you've just discussed. What kind of behaviors tend to raise red flags that go beyond the ordinary conflict or personality clashes?
So I would say, again, it all ties to the protected classes: age, race, gender, religion, national origin, disability, pregnancy, military status. So any hostile treatment will, in order for it to be unlawful in the workplace, must be connected to one of the protected classes. So if somebody is experiencing toxic treatment from a manager because there's a big personality conflict, but it's not related to any protected class, that will be a very difficult argument to make that it's a hostile work environment as far as the law is concerned. So typically what we see hostile work environment claims stem from discriminatory comments or treatment, inappropriate touching, anything of that nature that is related to a protected class. So obviously sexual harassment is unlawful in the workplace, but a hostile work environment can be created based on sexual harassment. It can be created based on age-related comments. It can be created based on somebody who's in the military and they are maybe they're in the reserves, and so they take weekend drill once a month or whatever the schedule may be. If that conflicts with their work schedule and their supervisor is making hostile comments about their military schedule, then that could create a hostile work environment as well. So usually what we see are hostile comments or treatment or conduct. It can be verbal or nonverbal, and it's directed based on one of those protected classes. That's what we usually see. And of course, the challenge there is proving that. So it's important that our clients document this, whether it be a recording or simultaneous notes to what they just experienced, or sending an email or a text message. People surprisingly put a lot in text messages these days that they don't realize maybe one day a lawyer might be going through those text messages. So I would say typically the best evidence that we see for hostile work environment are witness statements and messages, text messages or audio recordings.
Well, patterns matter, obviously, in these cases, I think. From what you've seen, what kind of repeated actions or comments usually signal that something a little more serious may be happening?
I mean, we see that a lot in sexual harassment cases, where it will start out with just kind of an offhand comment that someone thinks is a joke, that's slightly sexual but makes someone uncomfortable, and then it just escalates from there. I think it's very difficult to be in that type of situation as an employee, because if someone's doing that to you, you're probably just not sure what to do or how to respond. And I think that becomes even more complex when it's a superior or your boss. I think that happens to women a lot in the workplace, and men, and they feel very uncomfortable when comments like that are made, and don't really know what to do or where to turn, especially if the person doing it is a superior. Especially if the person doing it is a superior and there's no one above that person in the hierarchy in the company. So we see a lot of that, and I think that's something that's very difficult for anyone to deal with. And obviously it's illegal. So, it's important. What we really try to do is educate people as much as we can by, we write blogs on our website and via this podcast. And if anybody calls us for advice, we try to tell them what to do in that type of situation. But it's like Pete said, it's really important to, know what your rights are in a situation like that, document that type of behavior if it's happening, because it's almost always unlawful.
And so the law does require, in order for it to rise to the level of a hostile work environment, that the conduct or treatment has to be severe and pervasive to the extent that it interferes with the person's ability to do their job. So one-off comments that are made once or twice that are rectified shortly thereafter, not very likely to rise to the level of a hostile environment. It usually has to be a pattern of conduct in the workplace that is unwelcome, offensive, or abusive conduct or behavior. And that can be verbal, physical, or behavioral. And that is intended to create that type of hostility or intimidating environment for the person, or for the victim. So the harassers, or the person being accused of creating the hostile work environment, you have to be able to show that there was some discriminatory intent behind that treatment. It can't just be, they patted me on the back and tried to console me, and I felt that was sexual harassment, so I went and reported that. Even if somebody interpreted that and it was a one-time event, if the person engaging in that conduct didn't intend for it to be offensive, or intimidating or harassing, and it was a one-time event and it was corrected after that, that's going to be a hard argument to make as a hostile work environment. But if there's a pattern of conduct, the person has been notified that it's creating offensive environment, and the company's been notified and no corrective action has been taken, that's where we start seeing this is rising to the level of a hostile work environment.
As Rachel mentioned, power dynamics can shape how these situations unfold, but how does it change things when the conduct is coming from a coworker as opposed to a supervisor?
So it's actually a different legal standard. So whether the harassment comes from a coworker or a supervisor really changes the legal analysis very drastically. But what you have to know if it's a coworker is that if a coworker is making comments to you, or sexually touching you, doing anything that's causing you to feel uncomfortable, you have to report it. That's the first step. You have to report it to HR. If there's no HR, you have to report it to some type of superior, and the company needs to take that report seriously, and it needs to do an investigation and try to understand whether that behavior is inappropriate or not. And if it is inappropriate, it needs to take action. And it's difficult to say what that action needs to be, because what the law says is that the employer needs to act reasonably once it becomes aware that that type of behavior is happening. And what reasonable means can differ in every situation. But the first thing to know is that you absolutely have to report it. And you ideally should do that in writing, via an email, and you can blind copy yourself on that email or print a copy of it, but you have to keep a copy of it, because what we see happen a lot is people will make a report like that, and then if they get fired and it's on their employee email system, they lose access to it. So it's very important that you document it and you keep a copy of it to protect yourself in the event that something happens and you're let go and you can no longer access the email that you sent it from.
When somebody is dealing with ongoing harassment tied to a protected class like gender, race, disability, pregnancy, or age, what usually becomes important in understanding whether the experience meets the legal standard?
Again, I would say obviously the person's their own interpretation of what's happening. Obviously, if there can be a consensual relationship with a colleague, but if that consent ends, then any type of follow-up conduct or treatment should also end along with that. And so we've certainly had cases where sexual harassment cases that may have started off in a consensual relationship and the relationship ended, and then one party decided they didn't want the relationship to continue, but the other party disagreed with that. And if that occurs in the workplace, that can still constitute a hostile work environment, even if at one point it was a consensual relationship. And so ultimately, it whether it's based on age, race, gender, religion, disability, that the level of hostile work environment will depend on how severe and pervasive it is for the individual, how often it happens, the extent of comments that are made, the pattern of conduct, the frequency, and of course, whether the employer was made aware of it and given the opportunity to correct it. Unfortunately, what we see often is people will experience this and they will resign, understandably, if they want to remove themselves from a very toxic environment, but then they'll come to us and say, hey, I was harassed and then I resigned. I want to sue the company. But if it was never reported or documented, and allowed the company to take some type of corrective action, it may create a difficult argument for us as well. Of course, depending on the power dynamic. If it's the owner of the company doing this, of course, you're not going to report to the harasser, hey, you're making me uncomfortable, and expect that person to make a change. So the power dynamic makes a difference as well. But if there are avenues within an organization that somebody has the ability to report it to, and it's not the individual creating that hostile environment, then it should be reported.
So your advice to somebody who's not sure if they should report or not report would be?
I always tell people to report it. And even if they plan to leave, if they say, look, Pete, I can't handle this environment anymore, I have to get out of here, I say, at least put your report in writing and see how the company reacts. And oftentimes what we'll do is, if it is that bad where the person says, I can't continue to work there, we will try to intervene on their behalf and say, hey, put our client on paid administrative leave, and we'll try to negotiate an appropriate resolution here, whatever that may look like, whether that involves our client separating from the company with some type of severance package and releasing the company from liability, or maybe a change in department. Or sometimes I've even had where we report the misconduct to the company and the company terminates the employee who's at fault, the one creating the hostile work environment, after, of course, they've conducted an investigation. It's rare that we see a company take a corrective action like that, but it has happened. And then it rectified the work environment, not only for our client, but probably for other people as well.
I find that interesting. Why do you think that that's so rare to find a corrective resolution such as that?
But because in essence, it's the company acknowledging that there was some wrongdoing, which could expose them to liability.
Okay. Anything to add, Rachel?
Yeah, I think to piggyback on that, what I've noticed is that in situations like that, if a company just deals with it in the right way, the person probably would never come to us. I mean, I think everyone understands that an employer cannot control the actions of every single employee, right? But if you become aware that someone has done something inappropriate or done something wrong, it needs to be dealt with, and it needs to be dealt with in the right way. And, the right way is different in every situation. But I think certainly if you become aware that someone has sexually harassed another employee, it needs to be dealt with very decisively. And we don't always see that. And I'm not sure why. And I think the answer is probably exactly what Pete just explained, is that there's this reluctance to, admit that something went wrong. But, if you do and you just deal with it appropriately, then it would likely resolve the situation, and lawyers would probably never need to get involved in it.
And to add to that, I would say if if the company does take corrective action very quickly after learning of the report, it makes our argument more difficult if our client is still trying to argue for some form of damages, or an adverse action. It makes it more difficult if we're presenting to a jury and trying to argue that this hostile work environment was created, and the company can show, hey, look, as soon as we found out about it, we did what we could to fix it and resolve it. It would certainly water down our argument, and that's a challenge that, if it's corrected and fixed, then really we shouldn't be suing the company as a result of it. Usually the lawsuits that we get into are because the company did not take a corrective action.
Well, without discussing confidential details, can you share an example of a workplace situation that initially didn't look serious, but ultimately met the definition of a hostile work environment once the full context came together?
Yeah, I had a client who had a pretty significant disability that was, disabilities can be very different. There are some that are obviously very physically apparent, and then others that, people suffer from all different types of, psychological disabilities that are not physically apparent and are much more difficult to understand. But my client had a pretty apparent physical disability and came to me and told me just initially that, he had been receiving negative comments from a couple coworkers. And I don't know if it was that he was proud and didn't want to tell me all of the details at first, but once we started talking and I started asking pretty in-depth probing questions, he really started telling me much more than he ever shared with me during the intake. And I realized just how awful it was. And he was getting comments from people every single day, about his physical limitations. And it was heartbreaking. It was so sad to hear that someone was being treated like that on a daily basis. And it just really infuriated me, if I'm honest, that he was dealing with that. And it was over a very long period of time. So sometimes we learn a lot about our clients, the more we talk to them and the more questions that we ask and the more trusting they become of us. And that information helped me negotiate a really successful severance package for him. And he was able to leave because of how candid he was with me. And that's just really very fulfilling for me. Like, I felt really good about what I was able to do for him because I can't imagine someone having to work in that type of an environment every day. So yeah, that was a situation where I learned much more than I had initially known, because I kept asking questions.
Yeah, I've had cases like that too. One that comes to mind was a race discrimination case, where my client was very proud to be in the industry that he was working in, a very modest and humble person. And so, didn't want to, it was working in a predominantly white rural, environment, and didn't want to come across as I don't like the term pulling the race card, but he didn't want to make it seem like he was making frivolous claims. And when I saw the evidence of the type of discriminatory treatment that he had been experiencing, racial slurs written on his locker, a noose was someone put a noose in his locker. I was shocked. And he had pictures and witnesses and messages, and the company allowed this type of misconduct to go on. But he was surprisingly reserved in explaining it to me when I was probably more furious about what he experienced than he was. It was almost like he became, jaded or callous from the situation because of what he experienced. And I'm glad that he was forthcoming with me eventually, because we were able to get him a really good outcome for the tragic conduct that he had to experience.
Well, as we wrap up here, and for employees in Ohio who start to suspect that they are a victim of a toxic or unfortunate environment, what are some first steps that you'd encourage them to take, maybe even before they reach out to you?
I would say document what's happening. Take notes. If you can create a chronological timeline is always super helpful for an attorney to see. If we can get that from a client and understand what happened from the beginning to the present, that is more helpful than anything else. So just write down what you're experiencing, what the story is, what's happened to you and when and who did it. The more detail, the better. Anytime somebody can come to us with that, it's much more likely that, we'll be able to help right off the bat. It's just so nice to have that level of organized detail to be able to take a look at, because it makes it just so much easier for us to assess and review someone's potential claim.
Yeah, I would agree. A detailed timeline, and even if there are messages or emails or anything, is very helpful. Obviously, with artificial intelligence becoming more prominent now, we do get a lot of what we can tell our Chat GPT responsive prompts that somebody might have put their situation in and tried to understand what laws are violated. So when someone comes to us and they say, my employer's violating all of these laws, it's not as helpful for us because it's already making the conclusion, where we want the actual substantive facts so that we can decipher what laws are in play here. So I would say that's probably the most important thing, is getting that information together, and definitely contacting a lawyer before any serious decision is made. Maybe even if you're concerned at how you should report it, contact a lawyer. Absolutely call a lawyer before deciding to submit your resignation or anything of that nature that would potentially affect your legal claim moving forward.
Well, thank you, Rachel and Pete. And that is all for today's episode of the Friedmann Firm Podcast, Ohio Employment Law Guide. To learn more about Rachel, Pete, and the work their firm does for employees across Ohio, visit thefriedmanfirm.com. You'll find articles, resources, and answers to common workplace questions. Thanks for listening, and remember to leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.